So is there anybody in here that is hearing impaired? Okay, just checking, otherwise I'd have to find a microphone real quick. And I have a teacher voice, so I taught for about 14 years, so I can be pretty loud. Can everybody hear me?
Yes.
Okay. If anybody has a visual impairment, Jennifer in the back has the large print. And also, if anybody is completely blind, you can give Jennifer your email and we will send you a digital copy so you can use a screen reader. So Jennifer, wave your hand. That's who you tell if you need an accommodation during this presentation. Okay, my name is April Katine. Unfortunately, Pamela Ford is not able to be with us. She's ill, so I'm doing the whole presentation. Okay, so I am an advocate investigator with Disability Rights Florida. I've been there for a little over a year. Before that, I was at the Florida Department of Education as a director for 9 years. I also graduated from Florida State University with my bachelor's and master's in special education. I'm going to skip Pam because she's not here. So Disability Rights Florida is the state's protection and advocacy organization. We are funded under 9 federal grants, so depending on what the disability is, depends on which grant we use to fund our services. We are a nonprofit since 1987. We have offices all over. We serve the whole state of Florida. We have offices in Tallahassee, Tampa, Fort Lauderdale, and Gainesville, but we also have satellite advocates all over the state. So wherever you are in the state, our services will come to you, either virtually or in person, depending on the need. We have advocates and we have attorneys, so we are a legal-based organization. So our mission, and I'm going to read this, to advance the quality of life, dignity, equality, self-determination, and freedom of choice of persons with disabilities through collaboration, education, advocacy, as well as legal and legislative strategies. So that is what we do. The objectives for today: tips for preparing for an IEP meeting, who can help you if the IEP team and you don't see eye to eye, and some conflict resolution sessions, issues, options. So I'm going to go, some of the slides at the beginning I may go through a little faster. I want to have time to slow down at the end, and I want to be able to get through so that we can have some questions. If for some reason we don't get to your questions, because I do have a lot of information for you, our booth number is 505. In the exhibit hall, there's people to answer your questions. There's also an intake. So if you hear my presentation and you think, I've already asked the school district for something and they've already said no, that's when you can call us and do an intake. And we have advocates and we have attorneys. And depending on the issue, a lot of times you'll be assigned an advocate, but sometimes, depending on the issue, an attorney might be assigned. And sometimes you start with an advocate, and if we work all our advocacy tips and everything we know how to do, and we need attorneys, then you sign a different agreement with us and the attorneys get involved. We try very hard to solve it. Jennifer and I are both advocates, and we try our best to come out with a win-win for everybody, because honestly, what we care about is the child. So, you know, we are an advocate for the child, not for the parents, not for the school districts. The child is our client, no matter what age the child is. Okay, so IDEA is to ensure all children with disabilities have available to them a free, appropriate public education. You will hear people throwing the term FAPE around. That's what it means. And that means your child's needs get met in the school. So, is there anybody here that does not yet have an IEP? Okay, so I'm going to skip that. So, an IEP meeting often can be emotional. A lot of times there's a parent and maybe sometimes a friend, and then sometimes there's many, many people at the IEP meeting, and it can be very emotional and very intimidating. So some of the things we're going to talk about today are going to help you level the playing field for your child and for you to make sure you get what you need in order to be the best advocate for your child. Parents are important members of the IEP team, Sometimes it doesn't feel like that when the professionals are telling you about your child. Remember, when you start an IEP meeting, they should start with your child's strengths. That is the most important thing. We know they're always going to tell us about the struggles and the concerns, but they're supposed to use the child's strengths to help close that gap. So that's important. Okay. It's important before you go to the IEP meeting that you have all of the records. If they're going to do a draft IEP, you want to ask for it at least 5 days before. So you can send an email and say, I would like to, if you're going to use a draft, I would like to have it at least 5 days before to be able to review it and be a equal participant in the IEP meeting. It's important that you review them, you make notes, you note your child's strengths, you keep all reports. This is really important. And I was speaking to this mom over here earlier saying, the most important, if you hear nothing else today, everything the school sends home, keep a copy, okay? Make a binder for your child, and if they send home progress reports, report cards, behavior checklists, notes, anything, keep everything, because if you have to call us, we are going to ask you for, you're going to tell us the problem, and then we're going to say, what documentation do you have that you've asked for them to fix this? And I can't tell you how many parents say, I talked to the teacher, I talked to the principal. If it's not written down, it didn't happen. That is probably the most important thing I can tell you today. Keep good notes, keep records. If you have a phone conversation with anyone, follow it up with an email saying, thank you for talking to me, Miss Principal. I appreciate it. What I heard you say this morning is blah, 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 blah. If you disagree with what I think I heard, please return my email and tell me what's different. Because if they pick up the phone and call you, you say to them, I would like what we're talking about to be in writing. So I don't have time to talk. I'm a very busy mom, and please put it in writing to me. Most important advocacy tip. Okay. Okay, hang on, one more thing on there. Draft parental input. That's the other thing. If you're having trouble with a school, the most important thing, other than getting everything in writing, is to draft your parent concerns when you're at home and it's quiet and nobody's talking at you, after you've put the kids to bed, you sit down and you think of top 5 things that it could be 10 if there's a lot going on, but try and bullet it out and say, these are my concerns. This is what I'm worried about. This is what I'd like to happen, okay? Send it to them in writing so they can copy and paste it under parental concerns. Got it? Okay. Okay. So this is all about parents giving their input. If you have private reports, this is a little tip. Read it thoroughly. Make sure there's nothing in that private report that will hurt your child. I've recently had somebody give a private report, and we're trying to find them eligible for SLD, and the private report said no indication of SLD. Don't give them that. If it's private and they don't know about it and you don't like what it says, you don't have to give it to them, okay? All right, so this is again talking about drafting that parent concern, making sure you're thorough, making sure you give it to them ahead of time so they can copy and paste. Know your rights. If you go to this website and it's in your handout, there is a great place to look up the state board rules and the federal regulations. So it's on the FDOE website. When I was director there, I got them to put this online electronically for every single parent, teacher, anybody can get it. Okay? Review the meeting notice. Make sure it says what you think the meeting's about. If it's not, ask in writing why it's not what you think it's about. Decisions at the IEP team must be made using data. So again, if your child is having behavior issues and they're just telling you over and over again they're disrupting class, ask for them to keep data, not just on what the behavior is. You want to find out what's causing it, which is called an antecedent. Okay, the cause is an antecedent, and you would want them to do what's called a functional behavior assessment, which is called a FIBA. If you hear, ESC loves their acronyms, right? Special education. So functional behavior assessment, and that is a behavior person looking at why your child's misbehaving. And then they have to develop a positive behavior intervention plan. Again, one of the most important things is schools should not be blaming you or your child for the disability. We see that a lot. We come in and we hear the child's just not trying hard enough, or or the parent's not involved enough, or this or that. As a teacher for 14 years, when I had a child that was struggling and having problems, my job as a teacher is to figure out how to help that child and figure out what I, as a teacher, can be doing differently. Yes, our teachers are very overwhelmed. They're very busy. I get that. But in that IEP meeting, there is no more important child than your child. And that's all that teacher should be thinking about, not the other 30 kids in their class, not what they have to do after work. Your child. Okay? This last one, receive all proposals, denials in writing. If it's not in writing, it did not happen. You're going to hear me say that over and over again. When I say proposals or denials, there's something called, and you can write this down, prior written notice of refusal. If you hear no at an IEP meeting and they're not willing to talk about it any further, you ask them to put it on a prior written notice of refusal, PRWN, PWN, sorry. So that's also a very important thing, getting it on paper, because that PWN tells you not only what they're refusing, but why, and what other things were considered. And again, if you call us, we're going to ask you, did you get a notice of refusal? That's what the PWN is, and we'll want to see that. Okay. So, I'm going to kind of skip this too, because I think everybody, is there still nobody in here that doesn't have, everybody has an IEP at this point, right? Okay, so I'm going to skip that. Okay. Don't be intimidated by the IEP process. Sometimes they bring 10 to 15 people, especially if they know that it's already a little bit controversial. Remember, you have the right to bring somebody with you. If it's not an advocate, you can bring a friend, an aunt, a grandparent. Even if all that means is they're there to take notes for you, they're there to be a second set of ears, so that when you get home and you're overwhelmed and you can't think about, well, what did they say about this? You have somebody to discuss it with. And you're not limited to just one person. If you have a friend who maybe is a teacher in another school, or you know somebody who's knowledgeable about your child, it is the law that you are able to bring whoever you want to bring. Okay, you got to tell them who you're bringing. And if you're bringing a lawyer, you have to tell them in advance, because then they're going to bring their lawyer. But you can bring whoever you want as long as you inform them that ahead of time that you're bringing them. Okay, so when you get to that IEP meeting, focus on your child's priority educational need. One thing that parents often forget, you cannot ask for a particular program. Like, you can't say, I want you to use Wilson Learning for my child to read. You tell them what difficulties your child is having, and then as a team, you come up with what interventions, what specially designed instruction your child needs. They don't have to do a particular program, but they have to meet the needs. And the programs they use, the reading program, the math program, the writing program, has to be research-based, and often the child needs multi-sensory, so they need to hear it, they need to see it, they need to write it, they need to do it. Okay, so it's important that those are the kinds of things you're saying. You're not demanding ABA therapy or this particular math program. You're saying, my child needs to learn how to read, and they're having trouble with phonics. What research-based program do you have that will teach my child how to read and close that gap? Okay. People to talk to. So we're going to talk a little bit more when I get to it about chain of command and how to not jump over people, because sometimes your best advocacy is to build bridges and resolve it at the lowest level you can. Now, if it's not working, you do move up, and I'm going to talk about that in a minute. Okay. So this is something that a lot of parents are confused with. They get to the IEP meeting, you get to an impasse, and the school says, we hear you, Mrs. Jones, but we think FAPE, remember that word I said earlier, free appropriate public education, we think FAPE for your child is X. And you're saying, I think FAPE for my child is Y. And you're at an impasse. Here's the problem. The school gets to have the last word before you use your procedural safeguard rights. Okay? That's your remedies, is all of the procedural safeguard rights that I know at every who has like enough procedural safeguards to wallpaper their house? Yes. You get them every time. They're tiny little print. Remember, they are on the DOE website, so if you want to blow them up, if you want to have them read out loud to you, you can go there for that. So they may say, we think this is fake for your child, and then you say, I don't agree. So we're going to talk about what happens, what are your rights when you don't agree. Okay, so I have on here due process rights, but that's the end of your procedural safeguards. There's many things you can do before you get to the procedural safeguards. Again, you're going to get everything in writing. You're going to bring somebody who's knowledgeable with you. Parents do not have the ability to override the team's decisions, but then we're going to talk about what you do. Staff sometimes feel like they must make decisions based on resources, cost, and availability. So many times parents come to us and say, my child can't have a one-on-one aid because they say that's the most restrictive you can do. Or they say it's too expensive, we don't have the staff, we have a staff shortage. Get all that in writing, because all of that, saying all that is illegal. Okay? So when they say it, get them to put it in writing. It is not legal to base any decisions based on their staff or what that school has. Okay? All right. Also, sometimes you will have an evaluation for your child or a reevaluation, and the school does it, and they come back and they say things about your child that you know is not true. You say, this does not, you're saying things about my child that I disagree with. I know my child better than you. So you can get what's called an IEE, an independent educational evaluation, that the school must pay for. Now, they will give you information about who they think you can use. You do not have to use the person. You could use who they say, an outside evaluator. What you must do if you ask for an IEE and you want your own person, you must, are we out of them? So you have to, if you have a person you want to do the evaluation, you have to give that to the school district. The only thing they get to say is whether that person is appropriately credentialed. So they're going to look at, are they a certified psychologist? Do they work with schools? Okay, so that's important. Because if you pick somebody who just works in a hospital or a medical model, you're not going to get the evaluation you need for schools. Okay, when we get a case, we are looking for a win for that child. We are looking to be creative. Sometimes parents come to us and they are very stuck on a particular thing they want. And often, when you have conversations with us, and we go deeper and we ask you lots and lots and lots of questions about your child and about what's been going on, we tend to find a lot of times, based on not knowing all the information, sometimes parents are asking for the wrong thing and in the wrong way. So it's very important to get as much information. Like I said, there's a lot of information on our website and the DOE website, and I will talk about it soon. How many of you have a subscription to Special Ed Connection? Raise your hand. 1, 2, 3, 4. Okay, so all of you should have, it is a free subscription through your Fiddlers. Do you all know what Fiddlers is? The Florida Diagnostic. Call them and tell them you want a subscription to Special Education Ed Connection. It is free. Florida Department of Ed pays for it for every parent of a child with a disability. Every teacher should have access to it, every school district. It's really your best research tool because you can put in exactly what you're having a problem with, and you will get cases to read, you will get tips. It's an amazing resource. So Special Ed Connection, ask your Fiddlers to sign you up for it. Okay. Share information about your child, including private reports, work the chain of command, stay connected, and attend all meetings. I know it's frustrating. I know it is probably the last thing you want to do sometimes because it's frustrating. But I can't tell you how many times we get a case and the school district says, I haven't seen that parent in ages. So sometimes they try and convince you they know best. You must stay. Let me say this, your best defense when you hit a rough spot, and almost every family does at some point with special education, is to get in there early and build those bridges. Bring those brownies to IEP meetings. It's important that you compliment the teachers when you see they're doing right. Everybody can find something a teacher's doing right. Start every meeting with appreciating those teachers, appreciating the staff. Even if you don't like what they're doing, they're working hard. And then when you get to the sticking point, you've built a way to talk to each other, that they know you appreciate what they are doing right. Because remembering that every single person is human, and every single person wants to hear that they're doing well, and then they're much more open to hear the struggles. Remember, when you are passionate about your child, sometimes it comes across as frustrated and angry. So it's really important when you're passionate to show them how much you love your child. You are sending your best child every single day to be in their care. But it's really, really important that your passion doesn't come across as raised voices, okay? You need to bring the voices down. If you need to yell and scream and hit a pillow before you go to the IEP meeting and get that anger out, because when people get angry, people stop listening, okay? Remember that. There's a book called From Emotions to Advocacy that is really good, and it talks about that. Get your anger and your frustration out before you go to the meeting so that not only can you hear them, but they can hear you. Because when people get defensive, they stop listening and they dig their heels in, and nobody wins there. Okay, learn the lingo. We have lingo, don't we? IEPs, FIBAs, BIPs, all kinds of things. So spend some time on Special Ed Connection. They have a great list of acronyms. Learn the lingo, because I know as a parent, it's hard to stop that meeting every few minutes and say, what does that mean? I don't understand this. But don't be afraid to do it. If they come up because they're coming up with new acronyms all the time. And I've had to stop meetings, and I've been doing special ed for 40 years. Okay, yes, I'm really old. So don't be afraid to say, I haven't heard that one before. Can you explain it and what it means? Because that's your right as a parent to understand everything that's going on. Not only do you want them to put things in writing, but put your requests in writing. Okay? Be prepared for the meetings, negotiate resolutions. This last one, seek compensatory education. I'm going to talk about that for a minute. If you ask for something, and let's say you get a no, and then you ask for it 6 months later and you get a no, and then you ask for it 6 months later and you finally get your yes, you can go back and ask for all. So what you do is you finally get your yes, and let's say you're asking for 60 minutes a week of speech services. I'm just going to use an easy example, but you can apply it to anything. You're asking for 60 minutes of speech services, you finally get it a year later, and once you get that IEP and it's documented that that's what you're going to have, you pull out that first email where you asked for it a year later, and you say, okay, now I need also 60 minutes a week since this date, and we need to figure out how to get them. So it goes on top of whatever. So like if your child's getting 60 minutes a week and they've denied it for a year, you can say, I want him to get 90 minutes a week until we're caught up on what he's owed. Because if you get no, 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 and you get a yes, from the first time you ask for it, they should be able to give you compensatory services going back. Okay, I'm going to take questions at the end because I have a lot to cover, so just want to remember that, okay? Okay, so I'm going to get to that. So here's the chain of command. Always start with the ESC teacher. Always start at the ground level, and then if you're getting no's, go to the principal. Now, there are things that sometimes parents try and get from the school, and remember, your procedural safeguards, your parental rights, has to do with state and federal law. Sometimes people come to us and say, oh, this teacher's awful, I want him fired, I want him out of there, or they say, you know, they're threatening to retain my child. Those kinds of things are not in the law. Those kinds of things are based on district policies and procedures. So that's where you work through the principal, the ESC director, the superintendent if you need to. But even IEP issues, IDEA issues, you always want to start with the teacher, because again, if you, let's say you start with the principal and you call that principal, the first thing that principal is going to do is call that teacher in and say, what's going on with this? And she'll say, or he'll say, I don't know, Mrs. Smith hasn't talked to me about it. And the principal is going to email you and say, talk to the teacher. You know, and again, the lower level you resolve it at, the more amicable things can stay, especially if you have a young child. You have a lot of years to deal with these people, okay? And so getting a reputation of, I want to cooperate, I just want what my child needs, instead of, hey, this parent's really difficult, and they come to meetings and they scream and yell, and our teachers go away crying, they're not going to want to deal with you. So always work those bridges, okay? The ESC director, every school district has an ESC director. So if you've talked to the teacher, if you've talked to the principal, you're still getting a no, contact in writing your ESC director and say, I would like a conversation. Have a conversation, and then whatever gets talked about, follow up with an email. Thank you for meeting with me. I understand you said the next steps are to do X, Y, and Z. And get who's going to do it. That's important. A lot of times you have a conversation with, say, an ESC director, and they say, I'll take care of it, no problem. Time goes by. Nothing happens. Get from him or her, who do I contact next week if I don't hear from you? Who am I working with? Usually there's like a staffing specialist from the district office. So getting the person's name and when you can expect to hear from them. Document, document, document. All right. This next part is my specialty. Talking about middle and high school. Are there any parents of middle schoolers or high schoolers? Okay, great. So, one of the coolest things that just happened, I'm so excited. State legislature passed a law to move transition planning down to age 12 or 7th grade. So, no other state has done that. So we have, there's a legislator, her name is Allison Tant Richards, and she is a champion for children with disabilities, and she got this done. So it's really, really exciting. So when you start talking, so 12 and 13, you should be doing lots of interest inventories. They should not just ask your child, what do you want to do when you grow up? Because a lot of times, I know when I was a teacher, I got professional football player, doctor, lawyer, basketball player. So you've got to do more investigation from children. It's not, what I used to say to my students when I was teaching is, that's great. I hope your little 4-foot child gets to be an NBA star. But if that doesn't pan out, what's your second choice? You know? So we work with it, we talk about it. But starting at 12 and 13, they should be doing lots of interest inventories. You should be making sure that what gets put on that transition IEP is about your child. It is about what your child's strengths are, what their desires are. And yes, a lot of times they say, oh, you're in 7th grade, this is so silly, you have so much more to learn. That transition plan can change every year. As children get more information, as they get exposed to the world, it can change every year. So, but what you don't want to let them do is put a very broad, the child wants to go to college, or the child wants to go to a career in tech. You're supposed to be looking at what the child is good at and where their strengths are. Based on your child's needs. If any of these questions is answered no, then they are not planning the transition plan based on your child's needs. A couple of other tips. If your kid, and you know, I know a lot of you have young children. You're going to blink and they're going to be in middle school. They're going to be in high school. So remember some of these things. Keep this PowerPoint as they get older. So, a lot of times they will create work-based learning for children and for young adults in high school, and they will do group things. They will like send everybody to Bell's to stock shelves, or send everybody to bag groceries at Publix. Your child's work-based learning should be based on what they want to do when they graduate. Because remember, children with disabilities have a little bit longer learning curve. So you don't have time to just play around with all these broad things. You want to say, your child's interested in computers. Let's start in high school. Let's put them in the office and ask them to be working with computers. Let's get them in a club for computers. Let's get them. So the idea is a lot of school districts, again, out of administrative convenience, will do these big group things. I just had somebody who they had a coffee shop at the school, and every kid was working in that coffee shop. And I had a parent come to me and said, my kid does not want to learn how to make coffee or wash coffee cups, or, you know, my child is into the arts and wants to work in television. And so we had to fight to say, just because you have this micro enterprise at the school doesn't mean that child has to wash coffee cups every single day. You know, it just, so you have to continue to bring your child front and center and what they want to do. This one is so important, the middle bullet. Students need to pass the TAPE, which is the test of basic education, to be enrolled in a career and technical programs. Wrong, wrong, wrong. This is something even technical schools will say, and they're wrong. And I've given you the Florida statute right here that says the TAPE is not an entrance requirement for a career in prep. Your child wants to be a hairdresser, your child wants to be a welder, auto mechanic, any of those culinary arts, beautician, any of that, they can get into a career and tech program. Now the rule says that they have to, the career and tech program, if they don't meet their reading, writing, and math, when they go in, they have to give them remediation. If they don't get remediated to, I think some places it's a 5th grade level, some it's a 9th grade level, they set the levels. When they go to get out, if they are an adult, so 18 years old with a disability, there is a TABE waiver. They do not ever have to pass the TABE in order to be in a career and tech program. They have to take the TABE, and they may have to take it twice, but there is a waiver for it. They don't have to pass it, okay? Okay, so talking about VR, how many people know about VR? Okay, a lot of you. Okay, so a lot of what schools say is, in their senior year, we're going to hook you up with VR. Wrong. Don't let them do that. That's too late. There's a lot of things your children can get from VR starting as early as 14. So there's the pre-employment transition services starting at 14. You do not have to be a client of VR in order to get it. You can get it through the schools. If your school district isn't doing it, pre-employment, they call it pre-ETS, another acronym, okay? If they're not doing it, you need to ask them about it, okay? Those are all the pre-employment really good stuff, teaching your kids how to do resumes, teaching your students how to talk to people on the job and not get fired. Lots of good stuff. Okay, now, the time to apply for VR should be specified in the IEP. Don't let it say when they graduate or senior year. Should be earlier. Starting at 16, they can apply for adult services. There is one caveat to that. The pre-ETS, if you apply at let's say your child's still getting a lot of good pre-employment services at 16, and you're worried, say they have a very significant disability or behavior problems, or you think VR might say they're not employable, you may want to keep them doing pre-ETS a little longer. Because what happens if you apply for VR services and you're denied, they say they're not employable, you can't go back and get pre-ETS. Because the pre-employment services are assuming you haven't applied yet and you are still potentially eligible for VR. So that's my only caveat about ending pre-ETS and trying to go. But remember, if you get a no from VR, and I'm going to talk about our CAP services in a minute, we work with VR, and if you get a no from VR and you think your child can get a yes from VR, but they're getting an early no, you can call us and we can help you. Okay, so this is our client assistance program. This is what I was just talking about, where, and I'm not going to read all this to you, you guys have it in your handout, but basically this is where you call us and you say, VR has denied my child tuition to their technical school, or they've said no, that my child's not employable. So remember, for children that are more significantly impaired, there's something I want you all, if you have a child with more significant impairments, to write down this: discovery process. The vocational rehabilitation will do what's called the discovery process for students with more significant disabilities. Usually that's students that are IND, intellectually disabled, in the schools. And they will, the difference of the discovery process does not look for jobs that are advertised out there. They take your students, they look for their strengths, and then they look for a matching need in the community. And they basically job carve for that student. And it may be part-time if that's what your student needs. It may, it may be doing a single thing. So remember also, if your child goes to career and technical and they can't pass all of automotive, but they can learn how to change oil, they can get credit for just what they can do and get a certificate that says, my child has passed changing oil, and they can go work in a, I know we're not Super Lube anymore, but Take 5 or whatever it is now. So remember, we want to expand children's possibilities. So the discovery process for kids with the most significant disabilities expands those possibilities. All right, this is more the things that we can do, a supervised referral to VR, how to navigate. Jen, how am I doing on time? Okay, you guys have this, and I really want to get to your breaks. Okay, conflict resolution. Okay, so facilitated IEP meetings, how many know what that is? Okay, a few of you. Okay, you can ask for a facilitated IEP at any time. So if you get a no, and you're like, people are not listening to me, this isn't working, you can either get a facilitator. If you're having trouble at the school level, not the district level, you can ask for a district facilitator to come in and help not only calm the waters, but keep everybody on track, make sure everybody's thinking and listening to each other. And then, if, let's say you've tried the district level and you want to bring the state in, they will provide a facilitator at no cost. Okay, no cost to you, the state will pay for it. And so that is a good thing to first stop. If you've really hit a wall and you need help, calling the Department of Ed, and there'll be the contact information in just a minute, and asking them to set up a facilitated IEP. One tip though with that, make sure you, just like I said, take your time to think about your concerns. Take your time to put your concerns in order of most important to least important. Because sometimes, if there's 3 things that you absolutely want to walk away with and you won't be happy if you don't, and you give them a list of 20 things, they're going to pick the easiest things to make you happy. They're not going to pick the most important things. So sometimes putting too much on that list works against you, because they're going to feel like if they can give you 2 or 3 things at the bottom end, they're going to go, look, we agreed to 3 things. Yeah, well, that's not, so don't put things on there that aren't going to make a difference to your child. Put your top 5 things, and the first 3 things on that list are things that are going to make a difference for your child. The next 2 things, great. If you get them, wonderful. But make sure you're strategic in how you're asking for things, okay? So that's the place you can go to find out about how to do facilitated IEPs from the state. State complaints. These can be wonderfully effective or completely ineffective, depending on whether you feel like you can point out from the DOE website and from IDEA and state board rules what the district is breaking, what laws they're breaking. Because state complaints that say, this teacher is ineffective and I don't like them, you're not going to get a good findings from that. But if you're saying, they're not teaching my child to read, and they've been doing the same IEP goals for the last 5 years, or 2 years, or 3 years, that's the kind of thing you put in a state complaint, because they will, and the nice thing about this, so facilitated IEP can happen within a couple weeks. State complaint, they have 60 days to investigate, and they will investigate. They will talk to teachers. You have a chance to turn in, all that stuff that I just told you to keep. They will ask you, where's your documentation? Where's your proof that you're saying they're not teaching your child, or they're not doing this or that for your child? So a state complaint is a good thing to use, because when DOE has findings, then DOE enforces those findings. You don't have to enforce them. Mediation. There are good and bad things about mediation. The good thing about mediation is it's fast and it's free to you, okay? The bad thing about mediation is if things come out during mediation and then you end up having to go to due process, anything that's said in mediation is confidential and cannot be used in a due process hearing. So you just have to remember that. If you do mediation, It can be wonderfully effective. I once had a child who wasn't getting they were deaf, and they were not getting any sign language. We used mediation and got them everything they needed very quickly, because it was so ridiculous to have a child sitting in class who couldn't hear the teacher and they weren't providing a sign language interpreter. Crazy stuff happens, I tell you. Okay. Again, you would ask for mediation through the Department of Education. This is where you request the mediation. Okay, so you can ask, this is the number for asking for a state complaint. This is the number for mediation. This is for everything. Mediation, state complaint, due process, everything goes here. You need to take a picture of it? Go for it. Okay. But you have it in your PowerPoint. All right, due process. Now I'm going to sound a little negative here because due process is expensive, it takes a very long time, and there is a bias against families and towards school districts. Every judge has gone to school, and every judge thinks there's no way a school district would purposely harm a child, right? So, yes, due process is your right, but again, you want to use everything else in your toolbox before you go in this direction, because unfortunately, due process takes a very long time. You could have an elementary school child, you're asking for something, before it's resolved, that child could be in high school. And all that water under that bridge of harm to that child. So that's why you want to use facilitated IEP, mediation, state complaint, and number one, advocacy. It starts really early, building those bridges and volunteering in that school and baking those brownies and everything you can think of, so that they know you're a reasonable person. So when you come to them and say, you're not doing right by my child, I want to help you figure out, let's work together to figure out what we can do. Okay? So litigation's cost prohibitive, expert witness fees can't be recovered. 2 years, you can only go back 2 years in a due process. All right, how much time? 10 minutes. 10 minutes for, and before you ask questions, I want to mention, please do not tell us about your particular child's, there's a place for that. It's booth 505, and you can talk all about your child's issues in an intake. But if you have general questions, I'm happy to take them.
Yes, just to make sure that I understand, to ask for the facilitated IEP meetings, is through the school, I ask the principal because, we're at the second level, or I just go directly to the district?
So if you want to facilitate a meeting by a district person, you can go and ask that from the ESC director.
ESC director?
Mm-hmm. If you want it from the state, you ask, here, I'll leave that up. You ask it from DOE.
If your child is given accommodations on an IEP, what do you do if they do the state test and are actually told they're not allowed to have those accommodations and they're not even given it?
So again, you need to document, depends how old's your child?
3rd grade.
Okay, so you find a way to document it, and again, it might be just emailing the teacher and saying, my child came home and said they weren't able to get, extra time or oral reading or whatever. Is this true? And a lot of times teachers don't know not to tell you the truth. And so getting it from the teacher in writing, because if you start going above the teacher and asking people, they're going to shut it down, they're going to cover it up. So just very innocently, hey, I'm just wondering, my child said they didn't get this. What happened? Was that just a glitch? And they'll often say, no, I was told they couldn't have it. Bam, you have it in writing. Then you go up the chain. Then you say, okay.
Also, during an IEP meeting, if you're requesting more time for speech or OT, are they allowed to tell you no? That they just can't give your child more?
So you want to have that deep conversation and find out why they're telling you no. Okay, are they telling you no because they have a shortage of SLPs? Okay, because then it's illegal to tell you no for that reason.
That would be why.
Okay, but Again, data, data, data. If your child needs more because they are not making the progress they should be making. Now, sometimes children don't need more, they need different. So you have to be careful about just always asking for more. You have to look at what therapy are they actually getting and why isn't it making a difference. So if they're giving therapy and they're not effective, then you have to find out, you have to talk to people and find out, okay, I see the child's had the same goal for the last 2 years and they're not making any progress. Why? And they're gonna talk, they're gonna tell you. A lot of times they'll tell you the child misses therapy or isn't trying hard enough. And again, when it's putting it back on the child, that's not okay. You need to ask for data. Okay, data, data, data. Yes, sir.
Yeah, two questions. One is to piggyback off of there. Is there a maximum amount of like related services, OT or speech that the state has, or is it based off of the kids?
It's need. Everything is based on the child's need. But again, remember, more is not always better. If they're doing ineffective stuff, giving them 60 minutes of ineffective stuff isn't gonna help your child. You need to make sure what they're doing, especially when they're pulling children out of gen ed classes to give it to them. You want the most effective so that your child's not falling behind from being pulled out and then not making progress with that related service.
I just have a question about the speech. So can they tell you that they give speech therapy in group instead of individual?
It depends on what they're working on. You know, obviously sometimes, like children with autism need to be working on pragmatics. And so you want a group because you want the children to be able to talk to each other and try and work on the social interaction of those children. So again, it every single time goes back to what is the child's need? Do they need one-on-one or do they need a group for what they're working on? So go back to the child's needs every time and go back to data every time. Are they making progress? Yes, sir.
Yeah, last question was, you were mentioning the district and policies and whatnot. Are they supposed to have those accessible for parents, you know, somewhere written specifically?
Yes, because if it's not written for them, then it doesn't matter. They could say it all day long because you always, if they tell you this is a district policy, always ask for it in writing. Because if they don't have it in writing, then it's just out there, it's a myth, it's best, you know, it's, I don't even want to say best practice, it's,
Can't prove it.
they can't, right, if they're not willing to put it in writing, there's a problem. So asking in an email for something, a district policy in writing is always good practice. And if they don't already have it somewhere, you want to get it in an email so that again, if you have to go up to like say the superintendent, you can say, well, why is this a policy? And is this really a policy across your district or did this principal make it up? You know, yes ma'am.
When they tell you something, oh, that's just best practice, they do it anyway, how do you combat that? Because I've heard that a lot.
Right, if they're telling you it's best practice and they don't need to put it on the IEP because we do it anyway,
Yes.
then get it. You always have a chance. Let's say you go to the IEP and you've already given them your parent concerns and you hear something like that at the IEP meeting, you can, the day after the IEP meeting, email them and say, I'd like this added to my parent concerns. I heard that X, Y, and Z is done in the schools because it's best practice. It's not happening for my child, so if it's best practice, why aren't you doing it? Again, your best place to get things documented is in those parental concerns, and you can do it before, but if things come up in that IEP meeting, you can send an email and say, please drop this in as an addendum to my parental concerns. Yes, sir.
So I work with a lot of kids that do not have IEPs yet, but the parents are telling me that they are getting accommodations in the classroom because the teacher is seeing the need. How do I help those families with getting that process started? Because the teacher's just doing it, right? So
Right.
there's no documentation or anything in that regard, and they just are told that,
Right.
that those accommodations are happening.
So there's two things. Sometimes they trial accommodations to see if they're gonna help the child. So if they've been doing it a little while and they're seeing that it's helping the child, they should either document it on a 504 plan, everybody knows what a 504 plan is, or an IEP. Because you can't give kids accommodations in the classroom without having it documented either on a 504 or an IEP. But that can be used to say, my child needs this, the teacher saw the need, and so let's have a discussion about at least a 504 plan, okay? Who hasn't?
Functional behavior plans. If it takes the district 6 months or 9 months to produce one, and you see this on a regular basis, do you file something with the Florida Department of Education on a systemic issue?
Yes. Yes. Any person, any organization can file a state systemic complaint. So it's a state complaint is what you want. Remember, it's a functional behavior assessment that leads to a behavior intervention plan. So they have to do the assessment that shows what's causing the behavior and how they measure things. They go in and do observations. But if you see it taking an inordinate amount of time and it's systemic, it's important though to have, if you're gonna do a systemic complaint, you need to know what the systemic is. Is it all children in such and such county that, so you want to be able to identify what the group is. You know, it's all children that are eventually found eligible for EBD, emotional behavioral disorder. You know, or if you see something happening, let's say that they put a child in a discipline and they stop giving ESC services in that discipline program, then your systemic complaint is every child in the last 2 years that have been in this discipline program that has an IEP. And then they can investigate that. So you have to keep in mind, what are they gonna investigate when you file that complaint? Who are the children you're claiming were harmed by it? And so sometimes you have to give them specific children, sometimes you have to give them a group of children that they can look at. Does that make sense? Yes, ma'am.
If an IEP meeting and things are not resolved or you're coming to an impasse, can you say, can we reconvene later?
You
Or-
can, but you again don't want to do more of the same. You want to
Yeah.
think, what am I going to come back to that IEP team differently? Am I going to ask for a facilitated meeting because it wasn't going well? Am I going to call Disability Rights Florida and ask for an advocate because you were getting a no? Our services are free. Again, we're all over the state of Florida. Right now, we're mostly doing IEP meetings virtually. So, you know, I hope you learn what we do because I'm very passionate, Jennifer's very passionate about helping your children. Okay, there are more handouts back there. If you want to take them for friends, you're welcome. Yeah, these are large print if you need, or there's regular ones. My husband, hold them up, honey. Okay. Okay, time's up. I'm gonna pack up and I'm headed to, by the way, Disability Rights Florida, if you have kids of transition age or almost transition age, we have a brand new toolkit. And if you wanna hear about it, it's so beautiful and exciting. In Bay Hill 29 at 11 o'clock is our next one. I'm headed there. So if you want to ask me individual questions, that's where I'll be next. Thank you so much for coming. I hope this was helpful.
How are you?